Hearing in the appeal of Boyd against the Public Prosecution Service for Northern Ireland.
Yes, Mr. Henry.
Good morning, my lords and lady. I appear for the appellant, the Public Prosecution Service, along with Ms. Cheshire. Mr. Donald Sayers appears for the respondent, along with Ms. Smith.
Mr. Sayers, Ms. Smith. Good morning.
Lords and Lady, this appeal arises out of a judgment of the Northern Ireland Court of Appeal handed down on the 10th of June 2024. That was a case-stated appeal decision. The court comprised of Lord Justice McCluskey and Lord Justice Horner. And this appeal concerns a particular provision within the Magistrates Court Order Northern Ireland 1981. That provision is Article 158A, and in particular 158A1. And we say the central issue in this appeal is whether that provision allows for an amendment of sentence by way of adding a component to a sentence passed. We also say that the effect of the decision of the Court of Appeal in Northern Ireland is to impose undue restrictions, and that a sentence can only be varied upwards or downwards within the context of the orders which already exist. Just by way of summary introduction, my lords and lady, from a basic principles point of view, we respectfully suggest to this court that a sentence can be made up of either a single order, or a sentence can be comprised of a collection of orders which in total make up the sentence. So it can be singular or plural. In this case, the aspect of the sentence in issue was a compensation order, and in due course I'll take you to the legislation which we say establishes clearly that it can be either a standalone sentence, a singular order, or it can be a component of a sentence made up of several different orders. We'll take you to the legislation which says that a sentence can be varied. And in very simple terms, we respectfully submit to this court that if a sentence can be comprised of a number of different components, then it can be varied by adding a component. And we respectfully urge upon this court that the answer to this appeal is within the statute and the statutory language itself. At the outset, we acknowledge the important safeguard within the provision that I'll take you to in due course. Article 158A1 refers to the interests of justice. That will play an important part because it will deal with the concerns which may arise on a case-by-case basis. For example, issues about the finality of sentence and so forth. We also respectfully submit that the prosecution interpretation of the provision 158A1 is consistent with the statutory language. The nature of the provision itself, which could be described as a slip provision or a slip rule provision. And thirdly, it's also consistent with the intent of the legislator behind the provision. Now, moving away from the appellant's case and touching briefly upon the respondent's case just for a moment. In a nutshell, the respondent's case is the word sentence, when it appears in Article 158A1, should be read to mean sentence order, i.e. singular. And they say the effect of that is, because it is a singular item, you cannot vary by adding an additional component to the sentence. We respectfully will submit to this court that that interpretation is strained. It's a strained interpretation of the statutory language. It requires reading in a word which doesn't appear on the face of the statute, and it's also in conflict with the nature of the provision, the language within that provision, and the intent of the legislator, we say, behind the provision. So, my lords and lady, the way that I would plan to deal with this appeal in terms of my submissions to you is first briefly touch upon the 1994 Criminal Justice Order for Northern Ireland, and that is in order to set out the particulars of the provision which allows for a compensation order to be passed. I can do that in relatively short compass, and then go to turn to the issue of sentence and deal with some characteristics of sentence before moving on to the provision in issue, which is 158A and 1 in particular, and then go on to make some observations respectfully in respect of the Northern Ireland Court of Appeal's decision. Then sum up by addressing some of the respondents' points, and in whatever time's left, deal with some of the authorities that have been included in the authorities bundle as well.
Are you going to address the question of whether it's academic or not?
I will, Lord. And
sorry. I mean to interrupt.
Could ask the same question.
I rather suspected that question might come from the outset in light of the respondent's written case. I can address that now, if your lordships would prefer. I mean, we do accept that it's a rather regrettable situation that we find ourselves in. We have acknowledged that the application for the 158A variation itself, in hindsight, ought not to have been made because of the passage of time. Approximately 18 months between the passing of sentence and the application to the district judge. That error of judgment does not necessarily render the resulting variation or the decision of the district judge as unlawful. But this appeal hasn't been taken as a result of concern arising from that individual sentence. The concern is the knock-on effect for other cases. So, without accepting that it is academic, if this court were to find that it were academic, then we respectfully suggest this is a classic case of the classic example of the kind of case that ought to proceed on an academic basis. The court has the decision of Salem within the authorities bundle. I can open it to you if you wish. And, but within that, it makes a relatively straightforward proposition. Academic cases normally ought not to be heard. There is a discretion to proceed. That discretion ought only to be employed where there is a public interest in doing so, or a point of law of general public importance. The example within Salem that is provided, but it's not an exhaustive list, is where there's an issue of statutory interpretation which will affect other cases, and it would be better to deal with it at an early stage rather than allow subsequent cases to be troubled by the same point arising again. So we respectfully say that if this case is academic, it falls within that classic example, and we do respectfully urge this court to continue to hear these.
Do you accept that the exercise of discretion by the magistrate was incorrect? That he should have, by virtue of the concession made, he ought not to have made the order?
I don't know that I can go that far, my lord. I realise that there's a tension between the two positions of, on the one hand, accepting that there is a problem on our part with delay. I don't know that that problem would go so far as to infect the district judge's decision with an unlawful characteristic.
Well, was that taken into account?
The delay?
Yeah.
It was.
It was?
It was by the district judge. It was one of the prominent features of the district judge's consideration, the passage of time and the difficulty in revisiting a sentence so long after the event.
But there's no question of this particular defendant being affected by what we here decide, is there? I mean, the possibility of a compensation order being made, as I understood your concession, that's not being pursued. Is that right?
We wouldn't take any issue with this court not interfering with the quashing order of the individual individual compensation order that was made in this case. Our concern is about the broader impact.
But the only basis upon which you can do so is if the magistrate got it wrong. He did take it into account. Yeah. He did take into account the delay, and in the exercise of his discretion, he still made the order. And so, I'd like to know where you stand.
Well, I'm not sure that I can refine the position any further than I...
Why would you not have made the application? I mean, what's the basis for saying that you ought not to have made the application? Surely it must be that it wasn't in the interest of justice to do so.
There is a tension there, my Lord. I appreciate that. If we say...
Surely you have to make your decision. I mean, if you say you're not going to apply in the interest of justice, you can't really turn around and say, actually, the magistrate was entitled in the interest of justice to make the decision he made. Surely the issue here is whether the magistrate ought to have declined to make the order on the basis that the interests of justice were not served because of finality.
Well, I think that would have to be correct, my Lord. I would have to...
Right.
Sorry, I didn't hear.
I would have to agree with...
You accept what's being put to you?
It's a neater way of dealing with it, because if we accept that the point is still alive, the point of principle is still alive, that we can arrive at a result on the basis of an acceptance that it wasn't in the interest of justice for the magistrate to make the order.
Well, I'm grateful for your Lordship's questions and happy to proceed on that basis.
So it means that we are in an hypothetical or academic position.
We are in a
and you are basing our entitlement to go ahead on our exercising the discretion that this is a matter of public importance, in particular because it's a statutory interpretation question that can affect many other cases.
And we say the archetypal classic example of that kind of a case in which the court ought to go on to hear, even though it is academic.
And that's Lord Slynn in Salem.
That's correct. If your Lordships would prefer, I can open that provision, the judgment review, but I rather anticipated the court was very familiar with it. So with that difficult issue out of the way, for the time being at least, my Lords, I wonder if I might ask you to... I'm assuming the court doesn't require me to open the facts of the case to the court. Might I then...
We've read the written cases and the statement of facts and issues.
And I then invite...
And the judgments below.
Thank you, my Lord. May I invite you to turn up then the Criminal Justice Order 1994. So that's in the authorities section of the hearing bundle. You'll find it behind tab number 3.
We're all working off electronic documents, so the page reference will be sufficient, but I don't know whether Mr. Sayers is working off bundles.
It's
happy with the page numbers.
So, happy with page numbers, there we are.
Page 211. And so what you're looking at on this page, my Lords and my Lady, is the statute provision which enables either a Crown Court judge or a magistrate court to impose a compensation order. One thing which doesn't actually appear from the electronic page that you have in front of you is the cross-heading under which Article 14 sits. It sits within Part 2, which is Articles 3 through to 17, and the title for that is Fines and Penalties. So it's the context in which the provisions for the compensation order, is set out. And then looking at...
I was just wondering what use one can make of headings in the context of secondary legislation in Northern Ireland, because the Interpretation Act Northern Ireland 1954 applies. And section 10.2 says that marginal notes shall, by which headings are, shall not be construed as part of the enactment. And,
they're not setting out the provision itself, my Lord, but as we'll come to in due course, whenever one is looking at a controversial interpretation, we say the answer to this appeal is within the statutory language itself, but if one looks beyond that to look at context, and I think that the headings, cross-headings or subheadings can be taken into account, albeit they're not making up part of the provision itself.
In Montilla, in relation to primary Westminster legislation, you can. But I was wondering what the effect of the statutory provision in Northern Ireland is, which enacts that marginal notes shall not be construed as part of the enactment. So how do you use a heading if it isn't part of the enactment?
I can simply say, my Lord, only by way of looking at context. And I'm not, I'm just running through my mind at the moment the distinction between an order which applies in Northern Ireland and an Act of Parliament. And but I don't think I can advance any better proposition, my Lord, that, other than it's providing context. So I don't suggest that that the cross-heading or the title itself should be read into the provision. It's simply providing context. So
you're not submitting or accepting that there's any difference between the approach in Northern Ireland and the approach in the rest of the UK on this issue?
I'm struggling to find a justification for a difference in approach, my Lord, so I don't think that there should be. So, my Lords, my lady, if I might ask you then just to turn your attention to 14.1, please. And I'm going to lay focus here in relation to two different parts of subsection 1, the first few lines and also the last couple of lines as well. So dealing with the first few lines to begin with, it reads, subject to the provisions of this article, a court by or before which a person is convicted of an offence, instead of or in addition to dealing with him in any other way, may on application or otherwise make an order, and after the brackets it continues, requiring him to pay compensation. So a couple of points arising from that, my Lords and my Lady. It is stated that a compensation order can apply or can be imposed instead of any other sentence, so as a singular standalone sentence in its own right. The defendant can walk out of a criminal court and the only penalty that has been imposed on him or her is a compensation order. Alternatively, a compensation order can be imposed along with other components in a sentence. So instead of or in addition to. So that's the first point to observe. The second point I respectfully ask the court to observe is in the middle of the second line, you'll see it states on application or otherwise. So the compensation order can be applied for, or the prosecution can encourage the sentencing judge to impose one, or the sentencing judge can impose a compensation order of his or her own motion. That takes on a potential greater significance when one gets to the end of this provision. The middle of one is dealt with what the compensation order would be for personal injury, loss or damage resulting from the offence. But if I could take your lordships and my lady to the last two lines, please, and after the semicolon, beginning on the right-hand side of the penultimate line, it begins, and a court shall. And it states, and a court shall give reasons on passing sentence, laying some emphasis on the word sentence, if it does not make an order, that being a compensation order, in a case where this article empowers it to do so. So it's creating a statutory obligation on a district judge, or indeed a Crown Court judge, to give reasons if they decide not to pass a compensation order. So one can read into that an obligation on them to consider the compensation order when this is the statutory language, the article empowers it to do so. I'm looking at the last 4 or 5 words. Now, just before leaving this provision, my Lords, I'm going to ask you just briefly to turn over the page or scroll down the page to subsection 9. This isn't terribly significant, but I thought I'd better take the court to it. This is the provision which tells the sentencing judge to take into account a defendant's means before making a compensation order, and that's as the district judge did in this case. And that's in A, so it states that the court shall have regard to his means so far as they appear or are known to the court. The second point then is at B, and that it applies where there is a confiscation order made under the Proceeds of Crime legislation and a compensation order to the victim. So one payment is to the court, one payment is designed to go to the victim. And it says where there is a tension between those and the defendant's means are not adequate to satisfy both, that the compensation order should take priority. But as I say, for the purposes of this appeal, that subsection 9 isn't terribly important, but we do lay some emphasis on the provision which empowers a sentencing judge to impose a compensation order, because it's clear that it is a sentence, can be a singular standalone sentence, or can be one of a collection of orders making up a sentence.
And sub 10 is to similar effect in relation to fines.
That's correct, my lady. There was a case of, in relation to compensation orders, the respondent's case refers to the Inwood decision. That was for your note. I'm not going to ask the court to turn it up, but it's in our papers, tab 10. It begins at page 304 in the authority section. That was, as I say, a 1974 Court of Appeal case from England and Wales. The power to impose a compensation order had only been introduced a short time before, I think the year before. And in terms, what the Court of Appeal were saying was that a defendant cannot pay a compensation order in order to avoid a sentence of imprisonment. That's a perfectly unobjectionable principle. But we say it doesn't have any application in this case. That's not what happened. It doesn't affect the variation question. So I'm next going to move on to the issue of sentence and touch on it before going on to 158A. Just through one example, I'm going to further demonstrate that a sentence can compose of more than one order. Do that by referring to page 19 of the main hearing bundle. And I'm going to refer you to the statutory provision which deals with the offence of harassment. Unfortunately, this isn't in the authorities bundle, so I'm taking the court to it through the written case.
Yes.
And so...
Paragraph 29.
Paragraph 29, thank you very much, my Lord. And if you see, it's divided into 4.1 and 4.2. 4.1 sets out the offence. 4.2 sets out the penalty. It's a hybrid offence which could be prosecuted in either the Crown Court or the Magistrates Court. I'll take you to 2B, which is the sentence for the Magistrates Court. It says, on summary conviction, a person guilty of an offence under this article shall be liable on summary conviction to imprisonment for a term not exceeding 6 months, or a fine not exceeding the statutory maximum, and importantly at the end, or both. So you can have a custodial sentence, you can have a fine, or you can have both. The sentence imposed for an offence of harassment can be comprised of 2 elements on the basis of the statute. And that is not an unusual formulation for statutory offences. Now, unfortunately, my lords and lady, within the 1981 Magistrates Court order, within which 158A sits, there is not a specific definition of the word sentence which attributes itself to 158A. I'll take you in due course to a definition of sentence elsewhere in the provision which says it's for that part. That's maybe Article 140. But unfortunately, there isn't. It doesn't specifically align itself to 158A. So I'll ask that the court turn up page 236, please. It's 236. And for those working off hard copy papers, that's behind tab number 6. If your lordships have that, what you're looking at is Article 140 within the 1981 order. This is the provision which enables a defendant to appeal against sentence and or conviction. As the court will no doubt be aware, there's an automatic right of appeal from the Magistrates Court to a higher court. In Northern Ireland, that higher court is the County Court. In England and Wales, it's the Crown Court. One needn't secure leave or demonstrate merit. It's an automatic right, provided the criteria within Article 40 are satisfied. So just looking briefly at 141. Subject to this article, a person convicted by a Magistrates Court may appeal to a County Court, A, whether or not he is pleaded guilty against his sentence, and B, if he did not plead guilty against the conviction. I'll touch briefly on 1A below that. It states that Article 6 of the Criminal Justice Northern Ireland Order 96, under which a conviction of an offence for which an order for conditional or absolute discharge is made is deemed not to be a conviction except for certain purposes, shall not prevent an appeal under this article, whether against conviction or otherwise. And that's provision which attempts to deal with the rather unusual nature of a conditional or absolute discharge, which if one receives an absolute discharge, it's not considered a conviction, albeit it's recorded on your criminal record. It can, in certain circumstances, be, for example, for the purposes of appeal, be considered a conviction. But that also bites to some extent in relation to the sentencing aspect, because a conditional or an absolute discharge isn't of the normal nature of another sentence or the kinds of sentence that we are used to dealing with: probation orders, community sentence orders, custody, that kind of thing. But we're coming to the more significant provision within Article 40, and that is 142. Within this, you will find the definition of sentence, the only definition of sentence that you'll find within this statute. It reads, in paragraph 1, so in relation to the provision which creates the automatic right of appeal to the higher court, in paragraph 1, sentence includes any order. We lay deliberate emphasis on those two words, any order. Sentence includes any order passed on the person for the offence, whether on conviction or in subsequent proceedings, not being, and then it sets out two exceptions. One is costs, doesn't apply here. And the second deals with paragraph 9, 1b of Schedule 5, which deals with pre-existing restrictions on appeal rights which pre-existed the 1981 order. So again, they don't appear here.
What that means is that the whole sentencing package, as it were, is available for the appeal court on a rehearing.
That's correct, Lord. And I mentioned context earlier. When we come to look at, I'll take you to another statutory provision just a second, which provides within a different Act, which provides a definition of sentence, uses very similar language. It's the slip rule for the Crown Court in England and Wales. I'll take you to that. It's section 11 of the Courts Order 1971. And what I'm going to invite the court to consider respectfully is when a sentence is defined, it's defined in these terms, in any order. And obviously of much more relevance, Lady and Lords, is the 1981 definition rather than the Courts Act 1971 definition, but it is telling that they use the similar language.
But my Lord's point is that even if the offender appeals one part of the sentence, the appeal court has the whole sentence package
Precisely.
in front of it and can reduce or increase depending on the nature of the appeal.
It unlocks
the
pathway to dealing with the sentence entirely and each aspect of it. You're quite right, Lady. Just sticking with the Northern Ireland, I should say just before I leave, in fact, the Article 140 provision, whilst it limits itself in one sense in the statutory language in 142 by reference to paragraph 1 above, there are references to appeals within Article 158A1 itself. So appeals have some purchase in the controversial provision that we're going to examine. I just flag that to you now. May I next ask you to look at page 218, please. And if your lordships have turned that up, that is the Criminal Justice Northern Ireland Order 1996. And specifically, you're looking at Article 2, the interpretation provision within that piece of statute. The interpretation begins at Article 2.2, and it is the second entry on page 218 that I'm going to ask you to examine. It refers to community sentence. And if you have that in front of you, community sentence means a sentence which consists of or includes one or more community orders. So moving slightly away from the definition issue to ground I've already covered a moment ago, that a sentence can comprise of one or more components. And just before leaving this 1996 order, I would ask that the court to turn to page 2 to 3, please. And the reason for asking you to look at this provision is, again, repetition of demonstrating the point that the sentence can consist of more than one part. You'll see this is Article 8. The title is Restrictions on Imposing Community Sentences, which we've just looked at the definition for. 1 states that a court shall not pass on an offender a community sentence unless it is of the opinion that the offence or the combination of the offence and one or more offences associated with it serious enough to warrant such a sentence. The more important provision is 2, in particular the first 4 or 5 words of 2A and 2B. It states at 2, subject to paragraph 3, where a court passes a community sentence, the particular order or orders comprising or forming a part of the sentence shall be such as in the opinion of the court is, or taken together are, the most suitable for the offender. So again, Article 8 naturally follows the definition in 2 that it can comprise of more than one component, namely the community sentence. And then finally, for the 1996 order, I would ask you to turn over the page to 224. So that's page 224. And what you're looking at here, Lords and Ladies, is the provision which empowers a sentencing judge, either Crown Court or Magistrates Court, to impose a probation order. That power is contained in 10.1, Article 10.1. And before leaving that provision, I would ask you to look at 10.10. So that's at the bottom of page 225. And the reason I'm asking you to review this briefly is it states explicitly that if a probation order is imposed, the sentencing judge can still impose a compensation order along with other types of order as well. So 10.10 states, nothing in paragraph 1 shall be construed as preventing a court which makes a probation order in respect of any offence from making an order for costs against or imposing any disqualification on the offender from making, in respect of the offence, an order under Article 11 and 14 of the Criminal Justice Northern Ireland Order 1994, Article 14 being the compensation order provision. It goes on to talk about there being no restriction on driving disqualifications and restitution orders as well. Whilst I won't open it to the court, you'll find an identical provision for community service orders as well. And that you'll
provision for what, sorry?
On
identical provision for
community sentence orders.
Yeah.
So another variant of a community sentence, there's probation.
Which article is that?
That is Article 13, milady. And whilst I don't ask you to turn it up, it begins on page 647. And the equivalent provision that I've just taken you to in relation to the probation orders is at 1311 at the bottom of page 648.
And under the Criminal Justice Northern Ireland Order, a probation order is specifically categorised as a community sentence, is that right?
That's correct.
Okay. And how about a restraint order?
It wouldn't be characterised as a community sentence.
Right.
And
was the probation order characterised as a sentence prior to the 1996 order?
There was comment on it in the Leighton Buzzard Magistrates Court case, where
I mean, traditionally, probation emerged as a kind of a view about waiting to see if somebody rehabilitated themselves. So no sentence was passed until it was seen how the probation worked out. But I just wondered when did it become a sentence?
Well, I can't think of any.
And in particular, did it become a sentence before this order was changed?
That may explain Lord Will's comments in Leighton Buzzard, where he refers to it as akin to sentence rather than a sentence. I can't think of any example or point the court to anything before the 1996 order which attaches the word sentence to those community type penalties. such as community service order, probation, and so forth.
And a reparation order, what's the nature of that? At page 217.
Allow me one moment, Lord. It is a variation on a compensation order, effectively, my Lord. It's payment to the complainant. It's difficult to draw a bright line between a reparation order and a compensation order, I respectfully suggest. And if your Lordships and Lady are content, I would ask you next to look at page 198, please. So in exchange with Sir Declan earlier, I said I would take the court to the slip rule provision for England and Wales in the Crown Court, because it provides a definition of sentence within it. And on page 198, you're looking at the slip rule provision. The definition is found in a subsequent section, but just before leaving section 11, the slip rule is contained within 11.2. It reads, subject to the following provisions of this section, the sentence imposed or other order made. Just pausing there for a moment, Lords and Lady, that is almost identical to the language used in 158A, so the controversial provision within these proceedings. Language is not absolutely identical, but it's very close.
This is for the Crown Court.
This is for Crown Court, and rather than the Magistrates Court. So it says, subject to the following provisions of this section, a sentence imposed or other order made by the Crown Court when dealing with an offender may be varied or rescinded by the Crown Court within the period of 28 days, beginning with the day on which the sentence or other order was imposed or made, or where subsection 3 below applies within the time allowed by that subsection. Just a couple of brief observations about that. Number one is the deadline, or the limitation period, I should say, 28 days. That's not a feature of the provision 158A that we're going to come to in just a moment, the provision at the centre of this case. The legislator has chosen to impose a limitation period in Crown Court, but not in the Magistrates Court.
This is a legacy of the days of the assize, and this is the statute which established the new court system.
That's correct, my Lord. And I noted that when moving away from the assizes and into the new structure created by the 1971 Act, they imposed this limitation period. When the 1971 slip rule provision was subsequently replaced by Section 385 of the Sentencing Act 2020, that deadline, or that limitation period of 28 days was extended to 56 days, which is the same period which applies in the Crown Court equivalent provision in Northern Ireland, which you'll find within the Judicature Act at section Judicature Act Northern Ireland 1978 in section 49. No interest of justice reference within this slip rule. I just ask the court to note before leaving. So that is the slip rule for the Crown Court. It was, I should say, this provision wasn't to begin with part of the appellant's case, but it is dealt with in a number of the authorities which the respondent has introduced, so it is useful to look at it. I'd ask the court to turn to page 200.
Before you turn from 11.2, am I right in thinking 11.2 is a wider power than that with which we are concerned? It's not addressing a mistake at all, or a mistake, etc., and it would seem to permit the judge to have second thoughts.
On examining the statute, on the language used, there are no such restrictions to mistake or akin to mistake. So on one reading, yes, my Lord, and And I know that those are the comments that were made by Lord Edmund Davies in the Menocal case. There might be a discomfort in modern times in allowing a Crown Court judge to change their mind and have second thoughts. And I think the way that that was dealt with in one of the authorities, namely the case of Trigger, was to say that that has become a matter of sentencing practice rather than an express statutory restriction. So that a more succinct answer would be there are no statutory restrictions on the Crown Court within this provision, my Lord.
Thank you.
Is there evidence that this provision entitled you to make a different order, an order of a different kind, as distinct from interfering with the range, as it were, of an existing order?
Does Your Lordship mean by adding a new order?
Well,
or
substituting a probation order for a sentence of imprisonment or something of that kind? I mean, in other words, an order of a different type. I'm looking at what the meaning of the word varied is.
Well, I think in that instance, my Lord, one would be rescinding the existing sentence and replacing it with an entirely new sentence, changing so for example, going from a custody order to a probation order, or in the other direction, be a rescission of one and the introduction, that void would be filled with the introduction of another.
So varied in that instance would mean putting in something new?
It could, yes, my Lord.
Have we got or are there equivalent provisions for the magistrates?
The equivalent provision for the magistrates is 158A.
Yep.
So
I'm talking about England and Wales.
Oh, I beg your pardon. Section 142.
Yeah.
And we do have that within these papers. I'll open it to your Lordships in a short while. For your Lordship's information, it is described in virtually identical language. There are some changes, for example, to reflect the fact that the appeal, so I said earlier that the appeals feature in the Magistrates Court slip rule provision, if I give it that label just for a moment. The appeal in England and Wales is to the Crown Court from the Magistrates Court, whereas it's the County Court in Northern Ireland. So there are slight differences in language to reflect those distinctions, but otherwise they are materially identical. So, my Lords and my Lady, may I ask you to turn over a couple of pages or scroll down a couple of pages to 200, please? And what you're looking at here is an interpretation provision which applies to the 1971 Act and the slip rule provision at Section 11 that we've just been discussing. Somewhat with some hesitation, I'd refer to the subtitle of the provision, Interpretation of this Act and Rules of Construction of Other Acts. Interesting to see the reference to other acts, I thought, within that subtitle.
The Interpretation Act, Northern Ireland, does not apply to Courts Act 1971, so you're on very safe territory in referring to the headings and subheadings.
It's a very valid observation, my Lord.
Okay.
So 57.1 is where we find the definition. There are a number of words defined, and it is the third of those down. So just reading the top, it says, in this Act, unless the context otherwise requires. It's an interesting form of words for an interpretation provision. You'll see that it appears at the beginning of 2 and 3, I think 4 as well, below. It seems to have fallen out of favour by the draftsman because it tends not to appear in more modern, more recent statutes, but it states in this Act, unless the context otherwise requires, move down 2 words to sentence.
Sorry, I don't follow the point about it being odd. What do you mean?
Well, odd in the sense of unusual that it doesn't appear in more recent statutes. That form of words seems to have fallen out of favour.
Well, what do they use instead?
I don't think that it...
You're going to have something like that.
And it doesn't conflict with the approach that this court says it should be taken to interpreting a statute. For example, the case of For Women Scotland Limited. So I don't suggest that there's a suitable alternative, and I don't criticise the provision, my Lord. I'm just making the observation that it doesn't tend to appear in more recent statutes. But the definition of sentence, then, you'll see in relation to an offence includes any order made by a court when dealing with an offender, including, and I'll come to those examples in just a moment, but again laying some emphasis on the words any order within the definition of sentence, albeit not the 1981 order that we're dealing with in a different statute, but there is a consistency in terms of the language chosen by the legislator to define the word sentence. So it goes on to include two specific kinds of order. At A, includes a hospital order, and B includes a recommendation for deportation, which is something which a sentencing judge can make when passing sentence.
So it's the whole package again?
The complete package, my Lord. And
but how can we take into account this statutory definition in this statute to aid us in relation to the interpretation of section 158A?
I think at best, my Lord, I can say that it's of interest that the same form of words is used in the 1971 Act previously to that which is used in the 1981 order which we're dealing with. But I do accept from the outset that the definition within the 1981 order, namely Article 140, that was open to the court earlier, is much more telling than this. But it is that consistency of language in how sentence is described to include, as Sir Declan said, the whole package, the collection of orders that can potentially make up a sentence. So with those observations in mind, that's in particular that when looking at a sentence, it can comprise clearly of more than one component, and also when sentence is defined, is referred to as any order imposed. I now invite the court to turn to Article 158A, and you will find that on page 241. I beg your pardon, 239. And just before I open any of this to your lordships and milady, just by way of introduction to this provision, it was introduced by the Criminal Appeal Act 1995. There was no proceeding equivalent in Northern Ireland in the Magistrates Court Order 1981. There was a provision in England and Wales, namely Section 142 of the Magistrates Court Act 1980. And when the new provision was introduced by the 95 Act into Northern Ireland, at the same time, the existing provision in England and Wales was amended, and we respectfully suggest relaxed to remove some of the restrictions which previously applied. Whilst I won't open them for your lordships and my lady's note, the Article 158A provision was introduced by Section 27 of the Criminal Appeal Act 95, and that's on page 206. And the changes that were introduced in England and Wales were by virtue of Section 26, which is on the preceding page.
So the Criminal Appeal Act 1995 was a Westminster Act, is that
That's
right?
correct. I'm glad you made that observation, my Lord, because we do now turn to the title of title of the provision.
Yeah.
And I think that's where my respectful observations will begin. So the title above, so this is on page 239, Power of Magistrates Court to reopen cases to rectify mistakes.
But this is part of a Northern Ireland order. Yeah.
This was
not part of the... It was introduced by an act, but this is now an order, a Northern Ireland order, so not sure whether the Interpretation Act applies or not.
Maybe it got lost when it crossed the RAC.
May I plead the fifth in relation to that, my Lord? It's a little bit too controversial a topic for me to enter into. This, in terms of the title, or I should say the subtitle to this provision, it explicitly refers to reopening cases, to rectify mistakes, etc. The use of the word etc. Suggests that it is a non-exhaustive list. And it is interesting to note, I respectfully suggest, that the word mistake or rectify or equivalent language doesn't fall within the body of the provision itself. So 158A1. And what I'm going to invite the court to consider in due course is what statutory restrictions are actually imposed within 158A1. Just before I open it, though, I'm going to give the court some structure in relation to this provision overall. So one is what could be called the sentence provision in shorthand. Two deals with the issue of appeal rights insofar as the sentence provision is concerned. Three deals with convictions, so applying to vary or rescind a conviction. Just take a slight step back. It doesn't use the language of vary or rescind in 3, so I have to correct myself there, but I'll refer to that as the conviction provision. Below that, 4 is the provision which deals with the appeal rights insofar as they affect the conviction provision. And 5 deals with the fallout or consequences of setting aside a conviction proceeding under 158A3. It states that the sentence or order imposed shall no longer be of any effect. Finally, then, 6 allows the district judge sitting in the Magistrates Court to start any varied or replaced sentence from the day on which the original sentence was imposed, or such later date as the court sees fit. So it allows that flexibility for the Magistrates Court to adjust accordingly what might be in the interest of justice in an individual case. So with that in mind, I'm going to ask the court to return to 158A1 then at the top. And 1 can be divided into 2 parts, effectively, again divided by the semicolon at the beginning of the 3rd line. The first part is what provides the court with the power to vary or rescind. And the second part is declaring what that can potentially include, so effectively providing an example. So dealing with the first part then, it reads, Magistrates Court may vary or rescind a sentence or other order imposed or made by it. So that's a similar language that I referred to by comparison to the 1971 Act, albeit not entirely identical. It goes on to say, when dealing with an offender, if it appears to the court to be in the interests of justice to do so. So the statutory restrictions are that it must be a sentence or other order.
Well, is that just as clear as that? Because it could be sentences or other orders as well. The singular includes the plural.
And that's our...
but that's a matter of statutory interpretation. Singular includes the plural, does it not?
Well, that's our respectful position, my Lord, that against the respondent's interpretation of the singular, we say that this includes the collection or the plural. Beyond that, you'll see that the statutory restriction is the interest of justice. That's an important safeguard, as I introduced at the beginning of my respectful submissions, that on a case-by-case basis, there will be issues arising, such as the importance of the finality of sentence, delaying taking the application, whether the offender has completed the sentence already, potentially. A multitude of different aspects can arise in individual cases, and they will be governed by that interest of justice test.
Does a sentence have to comprise punishment or penalty?
I would respectfully suggest it can do, my Lord. I'm not sure that... take, for example, the compensation order. Its force is in compensating the complainant. Now, one could view it as a penalty imposed on the financial penalty imposed on the defendant. I'm not sure that I would go as far as to say every single sentence must impose an element of penalty. There might be a focus on rehabilitation, for example, through a community sentence. So just looking, if I may, at the second part of Article 158A1. This is after the semicolon, so the third and fourth lines. It states, and it is hereby declared that this power extends to replacing a sentence or order which for any reason appears to be invalid by another which the court has power to impose or make. So I mentioned a moment ago that that is effectively providing an example or a declaration of what the preceding power is capable of doing. It might be described as the classic example of what the power enables a magistrates court or a district judge to do.
But the variation in that case could be anything?
That's right, Lord. And it's not, the language is not exhaustive either. It's not saying this is all you can do. And just feeding into your Lordship's point, if one examines the statutory language used in 158A1, it's trying to catch all of the potential penalties, sentences that could be imposed on a defendant by a sentencing judge. So it's trying to encompass, the language we say is framed in such a way as to encompass them all. You still have the interest of justice qualification, so if the district judge isn't satisfied that it's in interest of justice to vary or rescind, it won't happen. But the preceding language is, we say, rather obviously designed to catch everything, to catch the collective, not just the singular. It would be rather unusual if you were able to rescind sentences and vary some sentences, but not vary by addition. It would, we respectfully suggest, create a bit of an anomaly if one were to interpret the provision that way.
So, in an invalid sentence, the theory is that you rescind it and leave nothing, and then you simply resentence.
That's correct.
As long as you're doing it in the interest of justice.
That's correct.
So,
not to introduce, I'm sorry, my Lord, not to introduce further complication to the exercise, but if, say, for example, the maximum sentence that could be imposed was 3 months and a district judge imposed 4 months. Yeah. In that scenario, it might be possible to vary, you're varying the existing sentence downward rather than rescinding and replacing.
Well, my question is, could you impose a probation order instead?
You could, Lord. sorry, Lord Justice.
No, well, sorry. What are you seeking to vary? Are you seeking to vary a sentence, or are you seeking to vary a sentence and other order?
The sentence, my Lord, we respectfully suggest.
And
Is that right? Why is the sentence or other order, or the sentences and other orders, not the package?
Well,
And you're being asked to vary the package? Or the power is actually to vary the package rather than the individual items?
we say, my Lord, that the provision itself allows to vary, using your language, the package in this particular case.
But not in other cases?
No, in this particular case, the compensation order was part of this sentence. So
Yes, but as a matter of statutory interpretation, you've got to work out what is it that you're varying. And the suggestion is whether varying a sentence or other order, or sentences or other orders, isn't actually a power to vary the package in whatever way the interest of justice suggests is right. So the test is the interest of justice, but the scope is the package.
oh, I respectfully agree with my Lord. I interpreted the last question as being, in this individual case, are we saying that it was the, are we classifying the compensation order as a other order or as part of this sentence?
It doesn't actually matter if you're looking at the package.
And I respectfully agree, my Lord. Sorry, my Lord.
On a conviction, does a court have to lay down a sentence?
Yes, subject to this, what I would refer to as a slight grey area when one comes to an absolute discharge, which isn't, for all purposes, considered a conviction and sentence, but you get slightly closer to the norm through a conditional discharge. So in the vast majority of cases, the answer to your question, Lord, would be yes. There's just that slight qualification that I can't give an absolute answer to it for that reason.
The only reason I ask is whether, if there weren't a sentence, whether you could use this power to impose a sentence, but you're saying that would never arise.
That's never going to arise.
And the discretion in the interests of justice to do so, as I understand it, you say this is not limited to mistakes. And as Carswell, LCJ, indicated, so it would never be in the interest of justice to do so if the Magistrates Court was taking on an appellate power or a reviewing power.
That's correct.
And so that is the method by which the extent of the power is limited, because there is a whole structure of appeal proceedings. There is no ability for the prosecution to appeal too lenient a sentence, and so therefore there could never be a review by which a magistrate decided, after all, that he was going to impose a slightly higher sentence. Is that correct?
That's correct, my Lord. And coming back to the beginning of your Lordship's question, is it restricted to mistakes? Are we moving in a direction where, or what do we say about the proposition that it's for mistakes only? In the vast majority of cases, the reality is that there's going to have been a mistake somewhere. We can come to a discussion about whether it needs to be a judicial mistake or whether it's one of the parties' mistakes which has informed and contributed to a district judge's mistake. But there's no such statutory restriction on the face of the statute. So whilst in practice, yes, in the majority of cases there will be a mistake, I don't go so far as to say that it is a prerequisite. And then moving on from that, your Lordship makes the point, well, if the statutory restriction is the interest of justice, when you get to a defendant who's attempting to manipulate the provision, so circumvent the appeal rights or something of that nature, it wouldn't be in the interest of justice to allow the provision to be used. It shouldn't be used as a surrogate appellate provision.
So if a magistrate imposes too lenient a sentence in the view of the prosecution, there can never be any opportunity for the prosecution to go back and say, you've got it wrong.
There is one case-stated appeal decision, I can't recall the name of it just off the top of my head, but if the sentence is so low as to be Wednesbury unreasonable, there's a potential way through the case-stated route to correct that unduly lenient sentence, but there is no equivalent of the Crown Court provision. So in the Crown Court, formerly the Attorney General, now the DPP, can take a sentence to the Court of Appeal if it's considered unduly lenient. There's no equivalent provision in the Magistrates Court, and so it has to be in a fairly exceptional case for it would have to be a fairly exceptional case for the prosecution to attempt to do that.
But if facts came to light that caused the prosecution to realise an error had been made and the sentence passed was too low, there'd be nothing to stop the prosecution using Article 158A. The magistrate may not agree, but
that's perfectly right.
It would be an available avenue.
That's correct. And again, it's demonstrating you're right in your proposition, and that is demonstrating again the importance of the interest of justice safeguard, because it'll be decided on a case-by-case basis. So there might have been an inadvertent error, or there might be a more serious case where the court was misled, and it's appropriate to use Article 158A to revisit the sentence that was imposed. But it comes back to what we respectfully suggest was the legislator's intent here, which was to catch the whole package and provide that ability to the district judge to revisit whatever was imposed, and then he or she will decide whether it's in the interests of justice to do so.
I'm so sorry. I was
just going to say, but are you saying, for instance, that the prosecution could come back in and say, look, we didn't draw your attention to these 2 or 3 cases which suggest that the sentence was too low? I mean,
that's never going to satisfy the interest of justice test,
yes.
My Lord. That is doomed to failure from the outset, I think.
Yes. Setting to one side the situation where the court's been misled, where the court has been proceeding under an obvious mistake or an error as a result. Is it really the case that the power under 158A1 could be used where the magistrates had second thoughts, or where perhaps they hadn't fully appreciated the extent of the injuries inflicted?
That's where you fall into the individual decision on the interest of justice. I think we'd have to decide it on a case-by-case basis. And I think that, respectfully, my Lord, there would be a danger in setting out specific categories of what is permitted and not permitted, albeit some of the authorities have attempted to do so. And one can look to what happens in terms of sentencing practice, but one would raise a bit of a red flag if the district judge had simply changed their mind about the appropriate sentence to impose and attempted to use 158A or Section 142 to revisit it.
But you don't have to go that far, do you? You don't have to say that it extends to such situations, because here there was a duty on the court to consider making the compensation order.
That's correct. In the circumstances of this case, that's correct, Lord.
I mean, otherwise you are placing a great deal on in the interests of justice. I mean, for it to be decided on a case-by-case basis might be regarded as slightly worrying, mightn't it? If one's saying, oh, well, it is within this power, we can change our mind tomorrow, overnight we've had second thoughts and we're now going to impose a custodial sentence, whereas yesterday we said we weren't going to impose a custodial sentence. If one said, oh, well, that's just, it wouldn't be in the interests of justice to do that. I mean, you're relying a lot on that phrase rather than saying, no, that's just outside what's meant by 158A.
I think your Lordship is correct. We are leaning heavily on the interest of justice provision, but the outcome of that, if it is properly applied, is a just outcome. So the concerns that your Lordship has are about...
But that is to introduce an appeal into the process, in effect, by virtue of Article 158A, and surely all the cases make clear that there are no circumstances in which that is likely to satisfy the interest of justice test.
I'm sorry if your Lordships have misunderstood. I'm not suggesting that it should be allowed as a surrogate appeal provision.
Yeah, but that's effectively what it would be if you're going to come to the magistrate and say, I think you got this one too wrong, and you should review it. Surely that is, in effect, an appeal process.
If you attempted to do so, yeah. Yes, my Lord, it would be an inappropriate application.
Yes, in other words, it would not satisfy the interest of justice test, which must have a methodology of ensuring that if there's going to be an appeal process, it has to lie within the statute.
I think that's a valid observation, Lord. And just...
From my perspective, part of your argument almost verged on the introduction of an application to the Court of Appeal for the sentence to be too lenient, which was introduced by statute. The interests of justice have got to be seen in the statutory context, and the statutory context is there is no appeal from a magistrate's court in relation to unduly lenient sentences. If the magistrate gets it wrong, he's got it wrong.
That's correct, Lord. And if I might call in aid my observation that I made earlier, that in the vast majority of cases, there will have been a mistake, and that will be why Article 158A1 is being employed. There is no such restriction within the body of the statutory provision itself, but in practice, that is the reality. That
mistake has to be a mistake. If it is a mistake by the prosecutor, I would have thought it would be very hard to establish such a mistake. If the prosecutor has been so inefficient not to bring the facts to the attention of the magistrate properly or adequately, I don't see that being a mistake. I see that being pure inefficiency.
I think Lord Justice McCluskey was right in relation to drawing that distinction between a judicial mistake, which could allow for 158A to be called upon, and a mistake by one of the parties, which wouldn't necessarily allow for that to happen. Where there is an interplay between the two, Lord, is where the prosecution or the defence make a mistake, and then that informs or partially informs the judicial decision, which then contains an error. So I think Lord Justice McCluskey was correct in his decision that really, if you're talking about the category of mistakes to which 158A applies, it really is judicial mistakes, but they do not in reality necessarily stand alone. Unfortunately, the lawyers or the parties in front of the judiciary may contribute to those, and potentially in a very significant way contribute to the district judge making a mistake. So this is, I respectfully suggest, a relatively good example of that happening, where there was statutory obligation to consider, in the circumstances of this case, a compensation order. The district judge considered, to some extent, a compensation order. The information that he required in order to make his decision wasn't there. That would have been relatively simple to correct. And the prosecution should have applied to adjourn and didn't. Thereafter, the district judge, we respectfully suggest, we're not too critical of the district judge given the prosecutorial error, but the district judge ought of his own motion not to have allowed the sentencing hearing to conclude that day ought to have requested, for example, that a phone call be made or there be a short adjournment to allow that information to be obtained. So that's, as I say, my Lord, that's an example of, we agree with Lord Justice McCluskey in relation to the judicial mistake issue, but this case is an example of where the conduct of the parties contributed to that judicial error in a very significant way. Or when I say parties, I should say party.
I suppose that what's just concerning me is you want to construe the word power under this provision extremely widely, only cut back by the interests of justice. It seems to me that there must be some initial restraint on the word power, for example, that it doesn't clash with another statutory provision, for example, provisions relating to appeals, before you ever get to exercising the interests of justice. Otherwise, you are really relying on magistrates being able to exercise the power, but actually, in the interests of justice, hopefully not exercising that power. I would have thought there's some restriction before you ever can come and ask the magistrates to exercise their power. I think that's just what we're trying to pinpoint. Is that not a...
It's a valid observation in your Lordship's. I understand your Lordship's concern. We are dealing with a provision which is intending to make good what has gone wrong before. If it is designed to apply to a number of different scenarios, hypothetical future scenarios which cannot be necessarily exhaustively predicted, whilst there is a heavy reliance on the interest of justice qualification, it's not an improper reliance, because one does work on the presumption of regularity and that the district judges are going to make the correct decision. The vast majority of cases, there will have been a mistake. That is why Article 158A is being employed. There might be hypothetical cases on the fringes where the power can potentially extend to, where there hasn't been a mistake, but the existence of appellate rights and attempts to circumvent those and so forth, that is something that can feed into the interest of justice consideration, and has done through some of the, it certainly has fed into some of the authorities, although perhaps not through the lens of the interest of justice test. I was going to make some observations about the respondent's suggested interpretation of this provision just before I leave it, unless your Lordships or my lady have any further questions in relation to it. What, as I said in a nutshell at the beginning, what the respondent is asking this court to do is interpret the word sentence, which appears on the first line, to mean sentence order in the singular. So it would read, a magistrate's court may vary or rescind a sentence order or other order. The reason that they urge this court to interpret it that way is to create the singular. We say in very simple terms, respectfully, that is out of step with the statutory language. It's out of step with the nature of the provision. It's out of step with the intention behind the provision. If one goes looking for the basis upon which one would adopt an interpretation which departs from the language on the face of the statute, where does one find the support for that interpretation? And I respectfully suggest the respondent's case is wanting in that respect. One could also stand back for a moment and ask what the public policy basis behind such a restriction would be. Why would you be able to vary and rescind a singular sentence and not the whole sentence? Why would you be able to vary and rescind another order and not a collective sentence. One struggles to find, from a responsible public policy making basis, one struggles to find what the justification for such an approach would be. And, if your lordships would just bear with me one moment. Lord Burrows asked about the English equivalent provision earlier. I might just turn that up for you briefly, if I may, just to demonstrate or make good some of the observations I've made about the comparisons between the two. So you'll find that on page, beginning on page 242.
Just returning to the search for the limitation on the power. The appellate procedure, of course, is available to deal with invalid orders made by the magistrate. And,
it would be, yeah.
So, at the moment, that, of course, is not a limitation on this power, because this is a provision that enables those errors to be corrected. So I suppose it would have to be, well, I just have difficulty in seeing at the moment how the appellate procedure, the appellate provisions actually limit the power if they don't limit it in cases of errors.
But just thinking of some hypothetical examples. I mean, say, for example, a custodial sentence is imposed of 6 months, the maximum period is 3 months. That can be corrected by way of a county court appeal.
Yes.
Even by way of a case-stated appeal, potentially, although one ought to go to the quicker route first. But that is still an example of, in which the 158A provision could be employed. It would be the classic example set out in the second half of 158A1. I'm not sure, though, my Lord, that it will that would cover all potential or all possibilities, and that the existence of
the appellate procedure in relation to the prosecution being able to ask for a case to sentence to be increased could limit the power.
It could, but
because the prosecution has no such right, and if it's made a mess of presenting the facts properly, that's the prosecution's fault.
That's correct, my Lord. And if the prosecution attempted to use 158A1 to increase sentence because it was unhappy with the magnitude of the sentence that had been imposed, that would be an entirely wrong effort on the part of the prosecution. That would fall outside of the interests of justice. It would be effectively a manipulation of the provision. If your lordships have section...
I suppose in a way the principle of finality also operates as a bar in relation to the interests of justice test in this area.
Well, it's going to be a significant feature in a lot of 158A applications, and it feeds into the period of delay between the sentence being imposed and the presentation of the application. The longer you leave it, the worse it gets, effectively.
Even why should one interfere with a sentence? There needs to be good reason, and the reason appears to be, in a lot of the cases, something akin to misapprehension or mistake.
Yes, and all of which will fall within the interest of justice. But, you're quite right, my Lord. I was going to briefly take the court through section 142. Just I'll not dwell on the language because it is effectively identical, but just a couple of distinctions. Section 142.1 is the sentence provision. 1A was inserted to it to introduce the appeal right qualification. And so 2 is the conviction provision within section 142. So whenever the court is reviewing the authorities, which are in the authorities bundle, a lot of the cases deal with section 142.2, which is the conviction section, rather than 142.1, which is the sentence provision. Although other than that, it is, so it's just a slight difference in terms of numbering, but other than that, it's largely the same. And if I may demonstrate to you the changes which have been made to section 142 through some of the two of the authorities. You'll recall, my Lords and my Lady, I said that section 142 pre-existed the 1995 Act, albeit in different form. So you'll find a summary of the changes on page 333. Not an exhaustive list, I have to add, but page, sorry, I beg your pardon, 334. And between D and G of the report, you'll see there's a paragraph begins, the amendments to section 142.2 made by the Criminal Appeal Act 1995 have widened the discretion of the Magistrates Court in 3 respects.
This is the conviction.
This is focusing on 2. And I'll take you to another case where they've helpfully summarised the differences. Williamson as well, which extends, their references extend beyond 2. And very briefly, it talks about at A, the power may be exercised in respect of a person who has been convicted, as opposed to merely being found guilty following a plea of not guilty, or being convicted in his absence. Prima facie, therefore, is available in respect of a defendant who has pleaded guilty. So that was a change. It wasn't available to anyone who had pleaded guilty previously. There's no limitation in time within which the power may be exercised. Previously, that limitation had been 28 days. So the Magistrates Court slip rule provision, as it was up until 1995, reflected the same limitation period as the Crown Court provision, but there was a departure between the two. From 1st of January 96 onwards. And then at C, the application to reopen is no longer required to be made before a bench constituted in the same manner or before a bench which consists of the majority of members of the earlier bench. So the direction of travel, albeit in relation to a different provision, the conviction was a relaxation of the provisions or a widening of the scope. Case of Williamson then, paragraph 28, page 470. Now, paragraph 28 is a long paragraph which begins on page 468, but terminates on page 470. It's a final paragraph within 28. And if you have that, my Lords and my Lady, it states a number of changes wrought by the amendment. The repeal of section 1424 did away with the 28-day time limit, and also the restriction that the application under section 142 should be dealt with by the same bench as originally dealt with the matter. The addition of subsections 1A and 2A made clear that the power could not be exercised after there had been an appeal. The language of the interests of justice, which was in the original Section 1422 was introduced into Section 1421. So it previously appeared in the conviction, but not in the sentence section. And finally, the last sentence reads, the restrictions in Section 1422, namely the power, could be used only following a not guilty plea or when the court proceeded in the defendant's absence were lifted. It's not a particularly striking point, but the general direction of travel was a relaxation. I should also say as well that in relation to both Article 158A and the England and Wales equivalent, Section 142, will come in due course to the mischief that the provisions were designed to, or as has been described in the authorities, the mischief it's been designed to avoid, and that was undue applications to the Court of Appeal via case-stated appeals or judicial reviews to the Divisional Court, and the resources that they use up. And that, we respectfully say, feeds in to the prosecution's interpretation of the provision. On the respondent's side, if their interpretation were accepted, it's more likely that those kinds of applications would have to be made. I was next going to open the For Women Scotland Limited case, but I'm just conscious of time, and I'm sure that the court is...
I was just wondering about the mischief. The alternative remedy here would have been an application for judicial review against the magistrate, seeking mandamus to compel the magistrate to make a compensation order.
That's correct.
And the time limit for that is... Yeah. Is that the appropriate time limit? If the mischief is to provide another avenue apart from judicial review, and the judicial review avenue, the gate closes after 3 months. Is that an appropriate time limit for the principle of finality?
In application to a 158A
yes.
application, so whilst it doesn't say 3 months, you could take 3 months as a marker, sitting as
yes.
a district judge considering the application.
Yes.
It's something the court could take into account. I'm not sure it's going to be determinative, but it is something that could be taken into account potentially. But really, the point with the delay would be that there is an obvious value in the finality of sentencing, and the longer one moves away from the sentence that was imposed, the less likely it's going to be in the interest of justice to interfere with that sentence, either by way of addition or variation, rescission, etc.
I mean, there may be more enthusiasm for interfering if the sentence is actually invalid.
It's a valid observation, Lord, in the sense that if you bypass the 3-month threshold, and an extreme example, 6 months custody has been imposed in a case where the maximum is 3.
It's not a very good example because he's probably served the equivalent of 6 months by that stage.
It's an interesting point, Lord, because you still couldn't allow an inappropriate sentence to lie on the court records and on the defendant's criminal record. You would still have to correct it. I suppose that, not to take too much of a detour, but one of the new points, the new point that the respondent is talking about introducing to this appeal arises from the comment of Lord Justice McCluskey in the Court of Appeal's decision, which was, it hasn't been debated in front of us whether the fact that this sentence is extant in this case, or by the time the district judge made the application, whether that's something that would have an impact. It is certainly something which should properly be taken into account. In many cases, it might indeed be determinative of the application, but we wouldn't accept that an extant sentence would be a complete bar to 158A or Section 142 being employed. Take this case, for example, if there was a compensation order imposed. If the compensation order had been imposed for £1,000 and the appropriate figure was 500, by the time the defendant pays the £1,000 into court, that element, that component of the sentence is extant. It is been satisfied, a bit like the defendant completing the hours of community service or serving the sentence of imprisonment. If that is clearly wrong, if the £1,000 was clearly wrong, then the fact that he's already paid it would not be a good reason not to use 158A to interfere with that and correct it to what it ought to have been.
So you say that if there's an unlawful sentence imposed which has been served in full, it still has to be put right?
Still has to be put right.
And it's within the power?
Absolutely. And we respectfully suggest that it would be important that it would be put right as well. It would be very unfortunate for the defendant if it was an onerous sentence such as community service or a period in custody and a mistake had been made, but it would still be necessary. His or her remedy may be elsewhere, and it would still be important to correct it.
Can I take you back for a moment to the breadth of the power for which you contend under Section 158A1? I notice you say, paragraph 69 of your written case, that it's not suggested that that article could be utilised by a district judge who'd reflected on a particular sentence and simply changed his or her mind as to what should have been imposed. Now, how do you reach that limitation on the power? Is it by reference to not being in the interest of justice?
Yes, my Lord. It would be extremely uncomfortable. I know Lord Edmund Davis had perhaps suggested that feeding in from the common law power which existed previously, that it might be possible to do that under the Crown Court slip rule. I would struggle to agree with that if it would not be in the interest of justice for a district judge to change their mind and say, impose a sentence on Friday and then come in on Monday or Tuesday and say, in fact, I think that wasn't high enough. I should impose a higher sentence. It would fall well out with the interest of justice.
What if the judge realised after the hearing that he'd failed to take account of relevant sentencing guidelines?
Again, you're balancing the value of finality in sentence, but I think in those circumstances, my Lord, it would again be difficult to interfere with the sentence in the interest of justice in that kind of scenario.
Because you're getting very close to an appeal.
And it would be effectively...
If it's too light, it should stay. And if it's too heavy, then somebody should use the appeal process.
I think that's right, my Lord. And yes, I can't disagree.
Can I just bring you back to the time within which we operate the finality principle? And that is a well-resourced prosecution service backed up by a police service. The obligation to bring judicial review proceedings would be within 3 months, but also promptly. And I was just wondering what your views are about that, because in this case, the victim was present in court in June. Sentencing took place in August. So she was actually there with the investigating police officer in a courtroom in June, and somebody could have asked her a simple question, and they didn't.
I don't seek to excuse that behaviour, my Lord, but in relation to the passage of time, I don't know that it's going to be possible to set specific time limits in place, because one doesn't know what eventualities are going to arise, and it is always... I know it sounds like a terribly unsatisfactory answer, but one never knows what's going to unfold, and cases are going to have to be judged on a case-by-case basis, and passage of time balanced against the value of the finality of sentence is always going to be an important consideration. Just a brief observation, Lord. The complainant of the main offending who was present that day in court was the partner. The compensation order was for the landlord, and who I don't think was required to attend that day. Not that that is material. But perhaps just one, again, hesitate to make this observation, Lord, but there was an interesting statutory amendment in the judicial review provisions in Northern Ireland, which retained the 3-month backstop limitation period, but removed the requirement to act promptly within, although I don't think that's going to have a terribly significant effect here. It's still going to be a case-by-case decision. So, as I said, my lords, I was going to open to you the 4 Women Scotland case. The reason for doing so was it neatly encapsulates the approach this court has suggested should be taken in relation to controversial statutory interpretation exercises. And just in the interest of time, I think I can probably summarise it by saying, and I'm referring in particular to page 509, paragraphs 9 through to 12. There's a useful brief synopsis of the principles to apply. It talks about the importance of the language, focusing on the statutory language. It does say in fairly clear terms that context is an important aspect. The context is derived from the section itself, where it falls within the statute, and what the surrounding sections say. There is, again, a particular focus, even through the context lens, there is a focus on the statute itself. There is reference to taking into account sometimes permissibly external materials, but I respectfully suggest that doesn't apply in this particular example, because the kind of external materials that the respondent is inviting the court to consider are things like the CPS guidance and the Crown Prosecution Service guidance and the Public Prosecution Service in Northern Ireland guidance, and those are not aids to statutory interpretation. And indeed, the Crown Prosecution Service guidance, which the respondent has included within the main hearing bundle, talks of a compensation order being a sentence as well. Returning to 4 Women Scotland Limited, it talked about trying to identify the intention of the legislator, as one does in every statutory interpretation exercise. There's some interesting observations made in relation to the presumption of words appearing in statute more than once and meaning the same thing. It might be appropriate actually just to open that to your lordships. If you would bear with me for just one moment, please. So may I respectfully invite the court to open at page number 510 and 511, please. And if at the bottom of 510, I just draw your lordship's attention to where it states about there being sufficient, so this is 4 lines down towards the right-hand side, just below G, but where there is sufficient doubt about the specific meaning of words used, which the court must resolve, The indicators of the legislature's purpose outside of the provision in question, including external aids, as described above, must be given singular weight. But then it goes on down below that, in the last 4 lines, just below J, that such aids, now I appreciate I say they are not applicable external aids in this case, but so such aids can explain the meaning of the statutory provision, which is open to doubt, and can themselves alert the court ambiguity in the provision, but they cannot displace the meanings conveyed by the clear and unambiguous words of the provision construed in the context of the statute as a whole. So basic.
As I understand it, you're not contending there are any aids?
Nor any ambiguity. And the language is clear. Our point is one doesn't need to stray beyond the face of the statute. The language, what we're saying is you simply apply what it says in Article 158A1. What the respondent alternatively is asking the court to do is read in a word which is not there, which distorts the meaning of and converts it from a collective into a singular provision, specifically around the word sentence. Now, I said I would address the court in relation to the presumption of the meaning of the same word appearing more than once. You'll find that in paragraphs 12 and 13, and that's on page 511, so the next page. At 12, it talks about Lord Nichols.
How does that apply in our case, sorry?
So,
What are you saying we need to apply a presumption of the same word?
so the word sentence appears in Article 140 in what I've called the County Court Appeal provision. Sentence is defined within Article 140 of the 1981 order. Now, it is within that definition stated to be for paragraph 1. So for paragraph 1 of Article 140. So there are limitations on the potential value of that definition.
But it's more than that, isn't it? Because the definition says that orders are to be treated as part of the sentence for the purpose of appeal. That's really what it says.
I think that's
so. It doesn't. It doesn't include orders. It creates the same distinction between sentence and order.
And that's correct, my Lord. And I'll always come back to the basic. I mean, our most basic proposition is one simply needs to apply the statutory language which is contained within 158A1.
But can you rely on a presumption of consistent application in circumstances where the statutory definition is limited to one section?
It's not my best point, I have to concede, Lord. There is a presumption that it means the same thing, but there is that obvious limitation at the beginning of the definition where it says for the purposes or for paragraph 1. So I'll not labour that point, Lord. So I'm just conscious of the time. Lords, I'd better move on.
It's open to you to use up some of your reply time if you want to. But I think from now on you're on borrowed time.
I heed that, Lord. I'm going to ask you now to turn up the Court of Appeal's decision, if I may. And that begins at page 118.
Just before you do that, you've probably told us, but what is it that you say your opponent has to insert? Which word has to be inserted?
The word order after the word sentence.
Okay.
And that the significance of that, my Lord, is to make the word sentence a singular item.
No, thank you.
It's relatively short judgment, but I think I'll focus on, if I may, 5 or 6 paragraphs within it. I'll start with paragraph number 1 on page 119. And what we have here is why the Court of Appeal was deciding a case-stated appeal, that the nature of what the district judge had asked the Court of Appeal to do. So one reads, by this appeal, by case state. 2 questions of law have been formulated for consideration by this court. I'm not going to address court on the second question, it's solely the first of the 2. Does Article 158A of the Magistrates Court, Northern Ireland Order 1981, empower the Magistrates Court to vary a sentence by imposing a compensation order in circumstances where a compensation order was not previously imposed? And you'll have seen in our written case that we laid some emphasis on the compensation order being part of a collection of orders making up the sentence. Running through that judgment, you'll see it turns to the statutory provisions in issue, chronology of the material facts on pages 120, 121, paragraph 4 on page 122. The court begins to look at 3 authorities. Leighton Buzzard, that's the decision of the Divisional Court in 1990, the Divisional Court in England and Wales. Paragraph 10, we've got re-DPP, which is an authority I'll return to, Northern Ireland decision of then Lord Chief Justice Carswell. And at 6, Williamson. Then the court looked at the 2 orders which had been imposed and quoted the words from them, probation and restraint order. More importantly then, paragraph 9, the central submission of Mr. Sayers, KC, was Article 158A1 of the 1981 order empowers the court to vary or rescind a sentence, or alternatively to vary or rescind another order. A sentence is, as a matter of law, distinct from another order. And critically, a compensation order is not a sentence but another order. So in the court below, the respondent's position was that the compensation order was not part of a sentence. The reason for that is because we were arguing that it was part of a collection of orders making up the sentence. That's somewhat at odds with the section, the final part of paragraph 10, where it says that the prosecution submitted that a compensation order fits neatly within the interpretation proffered by Lord Chief Justice Carswell and Lord Justice Wolfe, being an order akin to, but not necessarily a sentence. A compensation order may be imposed instead of or in addition to dealing with the defendant in any other way. We were making the case that the compensation order was part of a collection of collection of orders making up the sentence, and there's not a great deal more I can say about paragraph 10. The key paragraphs, I'm not sure that that's particularly significant though, because ultimately the court went on in paragraph 14 to find that a compensation order was a sentence. I'll come to that in just a moment. I'm going to focus now on paragraphs 12 through to 16. And in paragraph 12 at the bottom of page 125, the court does 2 things. It looks at what amounts to a sentence in the court's view. And then secondly, it makes a conclusion that the probation order imposed was a sentence. So beginning at the top, whilst Article 2 of the 1980 order defines order as including a decree or refusal to make an order, there is no definition of sentence, nor is such a definition found in the Interpretation Act Northern Ireland 1954. We consider that a sentence embraces any order made by a court following a plea of guilty or conviction, enshrining any of the well-established traits of every sentencing order, namely, and then what Lord Justice McCluskey does now is set out 4 characteristics, which he says points towards it, something being a sentencing order. 1 is the retribution of the offender. 2, the deterrence of the offender and others from offending. 3, the rehabilitation of the offender. And 4, in certain contexts, reparation to the victim. So that's the first part of paragraph 12. The second part then goes on to reach the conclusion. Final sentence, considered in its full statutory context, it is in our view clear that a probation order is a sentence. So we have component number 1 of the sentence imposed. At paragraph 13, the court goes on to address its mind to the restraining order. So that was the second order imposed by the district judge at the original sentencing hearing. And the question that the Court of Appeal asks itself is, does that amount to a sentence? And in terms, the court says it's not as clear a decision, but in the circumstances of this case, the restraining order does amount to a sentence. Just pausing there for a moment. At this stage then, on the basis of the Court of Appeal's findings, the court has concluded the district judge imposed a sentence composing of 2 different components, which feeds into the prosecution's interpretation to that effect, that a sentence can clearly comprise of more than one component. It's at paragraphs 14 and 15 we respectfully say that the Court of Appeal took a wrong turn. We have two findings, or 2 comments, I should say, in paragraph 14. One is about the compensation order being a sentence. The other is about how significant that is in the context of this appeal. So 14 begins, the correct classification of the compensation order by the Magistrates Court on the 31st of August 2023 is not germane to either of the questions raised for determination by this court. And we respectfully disagree with that. I took the court at the beginning of opening this authority to the issue, the first question of the case stated appeal, which is whether a sentence could be varied by adding a compensation order. And so we respectfully suggest that it was germane to the case stated appeal. I'll come in a moment just to the reformulation of the question that the court arrived at. But the court goes on in the 3rd line then of paragraph 14 to say the following. Notwithstanding, we consider it appropriate to make clear that the language of Article 14 of the 1994 order, reproduced in paragraph 2 above, in particular the words, is convicted of an offence and deal with him, impels inexorably to the conclusion that this is a sentence, i.e. compensation order is a sentence. The consideration that an order of this kind is also designed to provide reparation for an injured party does not deflect from this analysis. So that was one of the 4 characteristics described by Lord Justice McCluskey in paragraph 12 that might apply to an order which is a sentence or part of a sentence. So on the one hand, the court has concluded that a compensation order is a sentence. We respectfully agree with the court's decision in that regard and its reasoning. The statutory language in the 1994 order, Article 14, does compel any on any reasonable viewing to the conclusion that a compensation order is a standalone sentence or part of a combination of orders making up a sentence. The court then, having started to make the wrong turn at the beginning of paragraph 14 by saying that this issue wasn't germane, then continues at paragraph 15 to say, we return to the exercise to be performed. The statutory word vary is not defined. However, it is a familiar and uncomplicated member of the English language to be given its natural and ordinary meaning. Having noted above that this court is concerned with variation only, an intense concentration on the terms of the 2 orders made by the Magistrates Court initially on the 10th of August 2021, reproduced in paragraph 7 above, together with the later compensation order, is necessary. The question is, and this is where we say the court went wrong, the question is whether the compensation order made by the court some 2 years later constituted a variation of either of these orders. In other words, did the imposition of the compensation order amount to a variation of the probation order or the restraining order? The answer to that is obviously no. It was the introduction of a new order, which we said was a variation of sentence by way of addition, permitted by the statute. Now, the court, having reached that conclusion at the end, or framed the case in that way, at the end of paragraph 15, goes on at 16 to say, in our view, a negative response to this question is appropriate for the following reasons. First, the compensation order did not vary either of the earlier orders. We respectfully agree. The terms of both remained unchanged. Again, we agree. Second, the compensation order was something new and additional. Again, we agree. It was freestanding of both earlier orders, being a detached and self-contained new order. Again, we agree. But the question for the court was it permissible to vary sentence by adding a compensation order? The question was not, does the introduction of a compensation order vary a pre-existing probation order or a pre-existing restraining order?
Well, so far as Mr. Sayers is concerned, whether or not a compensation order is or is not a sentence or other order isn't actually all that important, because even if it is a sentence, he says you still can't vary on the basis of the orders that were made, as I understand his position.
Can vary by addition.
Yes.
I think that's right, Lord. Well, there are a number of different aspects to the Court of Appeal's decision. So I've taken you to this aspect. It's determinative. Once the court reached this conclusion and reformulated the question, that determined the outcome of the proceedings. The court did go on at paragraph 17 and 18 to address the issue of mistake. I'll not go back to that unless your lordships or my lady have any questions in relation to it. Our position set out in a written case, and I summarised it briefly earlier. It is a district judge's mistake which will allow for inter alia the employment of the 158A provision, but that can be contributed to by a mistake by either the prosecution or the defence, or even a deliberate attempt to mislead. The court also formed a view in relation to the second question, but that's not at issue before this court, so I'll not open that to you. And if your lordships would just bear with me one moment. On that issue of mistake, and our observation about the conduct of a party appearing before a court contributing to a judicial error, I would raise the case of Luxton, which Luxton, which has been introduced into this appeal by the respondents. It was not from memory, was not a Section 142 variation application, but it was a proceeds of crime case. The error by the prosecutor was to withdraw the proceeds of crime or confiscation order application. That contributed to the Crown Court judge making no order in respect of compensation, or sorry, I beg your pardon, confiscation. That's attached terrible significance to it, but it's an example of the outworkings of my respectful submission to the court about the conduct of the parties contributing to a judicial mistake. And it was held by the Court of Appeal to have been a mistake on the part of the Crown Court judge. I'll address briefly the impact, then we say, of this decision. Before I do, better just take the court in the interest of completion to the reframed question. Yes, paragraph 25 on page 129. The top of page 129. So the court begins, we consider that the first question in the case stated should be reformulated thus: was the compensation order imposed by the magistrate on the 31st of August 2023 a variation of either the probation order or the restraining order imposed on the 10th of August 2021? And we say that, as I mentioned earlier, we say that was a mistake on the part of the court for reformulating in that way.
So the answer they gave was correct, but they posed the wrong question.
It's a rather unusual scenario that I haven't found myself in before. That you're absolutely right, my lord. His conclusion, or the court's conclusion, was correct, but the question is what led the court into error, or I should say, the reformulation of the question.
Was there any? Was the question discussed?
No, my lord. There was no notice of the reformulation of the question.
This was an extempore judgment, is that right?
No, I don't think so, my lord. I mean, I'll be corrected on that. My memory might not be serving me as well as I would like it to, but I don't recall. Sorry, my recollection is no notice of the reformulated question and a judgment coming out a couple of weeks later.
Right.
The impact then, my lords and my lady, in relation to this decision, we say inevitably, whilst it is a slightly unusual judgment, what the Magistrates Court, district judges sitting in the Magistrates Court are going to do is, when faced with a scenario of variation by addition, are going to think that this is the correct approach, i.e. to that contained within the reformulated question. And that will unduly limit then the scope of the provision. And we provided as an example in relation to that, one of the more common examples, the failure to impose disqualification from driving when a defendant is sentenced, receives a number of penalty points. Those penalty points take the defendant's total to 12 or more, but for whatever reason, that is not realised by the court. For example, the paper part or the counterpoint of the licence which records the endorsed points is either out of date or not present in court. But for whatever reason, the district judge is not aware, and therefore does not, in addition to the fine, the penalty points, or I should say fine or other substantive sentence, does not impose a disqualification when he or she ought to have. And the statutory provision dealing with that is Article 40 of the 1980 order. I'll just, your lordships, bear with me. I'll take you to that.
I think everyone accepts that that is a worked example.
I beg your pardon?
I think everyone accepts. I don't see any dispute that that is a worked example of how it's worked.
I did take perhaps wrongly uptook the respondent to suggest that is, there are other ways to approach this proposition in relation to the disqualification, but maybe I'm being unkind or have misunderstood my learned friend's submissions.
Do we know what's happened in the 17 months since this decision was delivered?
No.
So far as penalty points are concerned?
No, we do know up to the point of September how many penalty points applications were to be made, but we don't know the up-to-date position, but can find that out for your lordships if you would wish. There were 140 applications between February and September of 2024 for what we would call totting up disqualifications which weren't imposed that ought to have been imposed. That information coming from the DVA.
But there's no information about whether this particular decision has been causing difficulty in the totting up procedures?
No, my lord. May I respectfully take the court to page 249 just to demonstrate or to make a brief observation in relation to this disqualification issue. And I don't think that this is controversial, but just for the sake of clarity. So this is Article 40 is on page 249, and it is 41 that we're referring to. The title is Disqualification for Repeated Offences, and it states that 1, where A, a person is convicted of an offence to which this paragraph applies, and B, the penalty points to be taken into account on that occasion, number 12 or more, the court must order him to be disqualified. The observation I make is that it is not a simple operation of statute that you might have in other criminal cases. So, for example, the notification requirements which would attach to someone convicted of a qualifying sexual offence. The judge doesn't need to impose that notification requirement on them. It is automatic by operation of statute. Whereas here, there is a requirement for the court to impose the disqualification, and that's why there's a requirement to bring it back to the court's attention if the error has been identified to correct it. So, my lords and lady, I think in the time that I have left, I'm going to address some of the authorities, although perhaps not all of them. Again, I do emphasise before doing this, emphasise respectfully that we say the answer is simply on the face of the statute. One reads the words and the answer is contained within that. But I'll begin with the decision in re DPP, so that's the Northern Ireland decision. And I'm going to ask the court to consider page 420. The decision itself, I should say, begins on page 415. You'll see from that it was a divisional court hearing. I know there's a difference in procedure. In Northern Ireland, the case-stated appeals are heard by the Court of Appeal and judicial reviews by the divisional court. I think in England and Wales, the divisional court hears both kinds of challenge. So in this case, this was a judicial review. The factual background to it is that the applicant for the 158A1 application had been the defendant in the criminal proceedings. It was to do with no insurance. And he had pleaded guilty and was attempting to argue that the sentencing provision within Article 158A, so number 1, would allow him to set aside his conviction effectively by to classify the guilty plea conviction as other order, the words that appear after sentence in Article 158A1. Now, for understandable reasons, the court and the decision handed down by Lord Justice Carswell, Lord Chief Justice Carswell, said no to that. It was not appropriate. And in talking about the limits placed on the corrective ability of 158A, it's following. I'm going to take your lordships to the comments on page 420. You'll see 4 numbered paragraphs beginning at the first of those numbered paragraphs. About a third of the way down the page, we're just beginning at C. You'll see it says the main purpose of Article 158A1 is to enable magistrates to remedy mistakes or to amend a sentence or order when they have imposed or made it under a misapprehension, and it is in the interests of justice that they should put matters right. In particular, the provision allows them to impose a sentence or make an order within their jurisdiction if they have inadvertently exceeded their powers within without the necessity to come to this court, the JR court, to have the sentence quashed. And here's the part that we lay some emphasis on. It is not, however, restricted to this, and the court may vary or rescind any sentence or order wherever it is in the interest of justice to do so. We do not, however, feel that we should attempt to define the power any more closely. Just pausing there for a moment, my lords and lady, there is a recurring line of authority in the, which was developed in the Divisional Court in England and Wales, starting with the case of Croydon and going through Home and Zykin, all of which are relying on one another, which use the language to the effect that the equivalent in England and Wales, section 142, is restricted to cases in which there has been a mistake or something akin to a mistake. What Lord Chief Justice Carswell was saying here is slightly different. He's saying that's really the typical position, but that restriction doesn't appear in the face of the statute, and it would be, reading between the lines, unwise to impose a solid restriction of that nature.
Mr. Justice Collins in Home is rather more open than perhaps than the judgments from Mr. Justice Burnett, as it was.
He doesn't, a bit more open. There's a clearer alignment with Lord Chief Justice Carswell's approach to the provision in the case of Trigger, which comes a little bit later than Holmes. It's more explicit than the departure in Holmes. I might just, with your lordships, just before
you have very limited time left, so it's a matter for you. I don't want to take you out of your way.
I'll wrap up with that reference. Just before I do, there's a similar note of caution sounded by Lord Chief Justice Carswell in paragraph number 5 at the bottom of page 420, but it was in relation to the conviction provision. You'll see just below H, it references the Croydon case. Below, the court said in Croydon that this is akin to a slip rule. We are not ourselves convinced that it is intended to be of quite such a narrow compass. The significance of Croydon is that it then feeds into every decision which follows through the Divisional Court in England and Wales and thereafter. Now I'm going to, that is a Northern Ireland decision, re-DPP. I'm now going to take you to a decision from England and Wales, the Divisional Court, where the court has taken a similar view, we respectfully suggest, to that of Lord Justice Carswell. And that's the case of Trigger on page 448, paragraph 32. And if your lordships have that, then paragraph 32, I should say, just by way of introduction, that this was a case in which a suspended sentence was imposed, and then the district judge was revisiting that to impose a period of custody. And that was said to be wrong on the facts of that case. But in terms of statements of broader principle, paragraph 32, the court states the following. On the wording of section 142 itself, there is no express limitation on the exercise by the court of what is expressed as a wide power to vary or rescind a sentence or other order imposed or made by it when dealing with an offender, except that it must be in the interests of justice. The title to the section refers to the power being one to rectify mistakes, etc. whilst Croydon, Magistrates Court, Holmes and Zyken, that's the list of recurring authorities that I mentioned earlier, all refer to the section being used to rectify mistakes, and there is no doubt that that is the most likely reason for exercising the power under Section 142. The wording of the section does not lead to the conclusion that it could not be used in other circumstances. So far as the time for the exercise of the power is concerned, equally there's now no time limit on the time within which it can be exercised. So that's why we say that the Divisional Court and Lord Justice Murbick and Justice Ramsey were aligning with the approach of Lord Justice Carswell to the equivalent provision. The significant point that they were both recognising, we respectfully observe, was there is no statutory restriction of the kind limiting it to mistake or akin to mistake. But in any event, we say that there was a mistake in this case. So in a nutshell, my lords and my lady, we say that in this case, the compensation order was part of a collection of part of a collection of order making up the sentence. And the statute says you can vary sentence, so you can vary by adding a component to the sentence.
Thank you, Mr. Henry.
Thank you very much.
Mr. Sayers will rise now. We'll hear you at 2 o'clock.